Good day everyone. Are you an alternative dispute resolution practitioner conducting mediation, arbitration, or any other form of ADR mechanism? Do you have what it takes to be OADR accredited and offer services to government agencies and have partnership with them thereafter? Let's get to know the fundamentals and requirements for the OADR accreditation, and you can be one of us. Now, it's time for us to dive in and get to know the OADR accreditation. Here is a summary of the 6 key points that we have to keep in mind. First, the OADR accreditation is mandatory only for ADR providers offering ADR services to the government, or have partnership with said agencies. Government agencies shall only partner with, or engage the services of OADR accredited ADR practitioners. Once accredited, they may provide ADR services to government agencies, such as, but not limited to serving as an ADR practitioner, providing ADR training, conducting program and system design, and managing, overseeing or administering ADR programs. Second, the OADR confers accreditation to individual ADR practitioners, private APOs, and public ADR program who have successfully complied with the requirements under DOJ Department Circular 49, Series of 2012. Third, an OADR certificate of accreditation is valid for a period of 2 years from the date of issuance or unless sooner revoked. It is renewable and shall only cover the field of practice, or the ADR mechanism indicated therein. Fourth, any certification or accreditation granted to an individual ADR practitioner by an OADR accredited private or public APO with an ADR program shall be recognized by the OADR for the period within which said APO remains accredited. Fifth, accredited APOs that intend to offer ADR trainings to government agencies are required to obtain approval from the OADR at least 1 month prior to the intended training date. And lastly, the updated official roster of accredited neutrals and APOs are posted online via the official OADR Facebook page, and the OADR webpage and the DOJ website. At this juncture, we are proud to present to you the updated roster of accredited practitioners per category. For the first category, we have the private ADR provider organizations, or the APOs. Presenting the Conflict Resolution Group Foundation Incorporated, the National Center for Mediation, the Philippine International Center for Conflict Resolution, Philippine Dispute Resolution Center Incorporated. The Philippine Institute of Arbitrators Incorporated.
The Mediators Network for Sustainable Peace, Incorporated.
The Philippine Arbitration Center in the Visayas, and the Calao, Prasad and Hofelenialo.
For the second category, we have the ADR practitioners and neutrals. Presenting the OADR accredited individual ADR practitioners and neutrals. For the third and last category, we have the Public ADR Program. Presenting The Intellectual Property Office of the Philippines. In summary, here are the figures on OADR accreditation as of this date. Any interested applicant may submit the following requirements for OADR accreditation. For ADR provider organization, for individual ADR practitioner or ADR neutral, and for public ADR program. For any questions and concerns, you may visit the OADR Facebook page or email us at acd.oadr.doj@gmail.com. Thank you.
Good morning. Before we formally start the program, please take note of the following important reminders. Foremost, please be informed that this convention is recorded. By joining, you are giving consent to the Office for Alternative Dispute Resolution, or the OADR, to record and maintain a copy of these proceedings and any information that will be exchanged throughout this event. Please observe proper decorum, refrain from using offensive language, and keep your comments relevant to the discussions in the event. Meanwhile, the post-event survey shall be posted on the OADR Facebook page following the third day of the convention. Please note that only those who registered, attended, and accomplished the post-event survey will receive an e-certificate. Should you have any reservation or related concern, kindly contact the NADRC Secretariat at nationaladrconvention@gmail.com. Please stand by. The program will begin shortly. We now commence the program with the invocation, to be followed by the singing of the Philippine National Anthem.
Lead me, Lord, lead me by the hand and help me face the rising sun. Comfort me through all the pain that life may bring. There's no other hope that I can lean upon. Lead me, Lord, lead me all my life. Walk by me. Walk by me across the lonely roads that I may face. Take my arms and let your hand show me the way. Show the way to live inside your heart all my days, all my life. me, Lord.
Walang pag-ibig, pero sa silanganan, walang ng puso, sa dibdib mo'y buhay. Lumang ibigang, tuyang ka na mag-ibig, sa matulugig, di ka masisi, sa daragat at pagsisibig, sa langit ang magawin, walang nagtulad, ang dawit sa pagnayang minamahal, ang gusto ng watawat dito, may nadakinig, ang bituin at araw niya, kailan pa may nagtibig.
Once again, a pleasant morning to our distinguished guests, dear participants, ladies and gentlemen. Welcome to the second National Alternative Dispute Resolution Convention for the NADRC 2021, C2, organized by the Office for Alternative Dispute Resolution and attached to this, the Philippine Department of Justice. Yesterday, we opened the convention with focus on how alternative dispute resolution is developing and appearing in the digital world, as well as updates on the Philippine ADR for 2021. For the second day of this convention, we focus further on how the world is digitalizing ADR, particularly with online dispute resolution. Nowadays, a lot of activities and transactions may be made right at our fingertips. With the onset of the pandemic, online platforms have also become a norm to meet some, if not most, of our day-to-day means of doing things, from communication, shopping, banking, to meetings, classes, and entertainment. Consequently, issues inevitably arise in between these transactions, be it offline or online. Making the most out of technology, online platforms can also be an efficient avenue to amicably settle disputes. With that, I'm sure that today's program would be as interesting and informative as yesterday's session, having with us both local and international resource speakers to provide timely discussions on ADR digital transformation. Stay tuned to our official online channel, the Office for Alternative Dispute Resolution, on Facebook and YouTube, as we provide you timely updates, information, and discussions on alternative dispute resolution in the digital era towards enabling a more efficient, accessible, and effective administration of justice in the Philippines. And now, to formally open today's session of the convention, it is my honor to introduce the OADR Executive Director 5, Attorney Irene D.T. Alogo, for the welcoming remarks. Attorney Irene is the inaugural Executive Director 5 of the Office for Alternative Dispute Resolution, an attached agency of the Department of Justice. She is a professor at the New Era University College of Law and Tarlac State University School of Law. She formerly served as Secretary and member of the Board of Directors of the Association of Government Internal Auditors Incorporated. She delivers lectures in mandatory continuing legal education covering topics in alternative dispute resolution. Attorney Irene is a trained government manager and a career executive service eligible. She has over 10 years of extensive law practice and has held key positions in all three branches of the government. Her passion for public service and desire to innovate is evident in her dynamic government service record, which includes her appointment as Acting Director 4 of the Internal Audit Service of the Department of Agriculture. Her designation as Court Attorney 5 at the Judicial and Bar Council, and as a Director 2 at the House of Representatives Electoral Tribunal. Prior to her appointment to her present position, She had her training on strategic conflict management for professionals at the Singapore Mediation Center and on comprehensive course on international arbitration under the Chartered Institute of Arbitrators, New York branch, and the Columbia Law School. She is also a trained arbitrator of the Philippine Dispute Resolution Center, Incorporated. Attorney Irene represents the Philippines as one of the delegates to the United Nations Commission on International Trade Law, Arbitration and Conciliation Dispute Settlement, and Investor-State Dispute Settlement Reform. Attorney Irene obtained her law degree from the Arellano University School of Law and Bachelor of Arts degree in Legal Management from the University of Santo Tomas. She is also a TESDA certified bread and pastry chef. Attorney Irene is the author of the book titled Philippine Alternative Dispute Resolution, which highlights the different ADR mechanisms and practices in the country like arbitration, mediation, ADR in the judiciary, ADR under the Katarungan Pambarangay system, ADR practice of indigenous peoples, and ADR forms. Her book, which features simplified illustrations of pertinent legal provisions, updated rules and procedure, relevant jurisprudence, and DOJ opinions, sample pleadings, and legal forms, aims to keep readers abreast with the latest developments in ADR. Ladies and gentlemen, let us all welcome the OADR Executive Director, Attorney Irene D.T. Alogo.
Justice Secretary Menardo I. Guevara, Undersecretary John Paulo D. Salvangan, UNCITRAL Director Ana Jubon Brett, UNCITRAL Legal Officer Ms. Caroline Nicolas, Arbitration Judge of the Court of Arbitration in Madrid, Spain, Ms. Teresa Rodriguez de las Heras Daniel, Mr. Kevin Nash, Registrar of the Singapore International Arbitration Center, Professor James Claxton, Associate Professor of Law of the Waseda University of Japan, Intellectual Property Office of the Philippines, Bureau of Legal Affairs Director, Nathaniel S. Arevalo, Attorney Mario P. Valderrama of the Construction Industry Arbitration Commission, representatives from the Philippine Dispute Resolution Center, the Philippine Institute of Arbitrators, the Philippine International Center for Conflict Resolution, the National Center for Mediation, the Conflict Resolution Group, and the Mediators Network for Sustainable Peace and Philippine Arbitration Center in the Visayas. Representatives from the United Nations Commission on International Trade Law, the Australian Competition and Consumer Commission, Embassy of Singapore, Korea, the Holy See, Panama, Papua New Guinea, Qatar, and Turkey. Distinguished resource persons, guests, and participants, our partners in the government and private sectors. Ladies and gentlemen, good morning. Over 4 decades ago, an American futurist named Alvin Toffler envisioned the evolution of human society as occurring in 3 waves. The first wave is an agricultural society, which is based on farming and hunting. The second wave is the industrial society, which is defined by mass production, distribution, and amusement. And the third wave is the information age society, which is driven by information technology. We are currently in the midst of the third wave. The information age society allows for arguably boundless opportunities. In this day and age, owing to the marvels of the internet and advanced digital devices, we can now hold a virtual conference that is simultaneously attended by participants from different locations and time zones across the globe. Its marvels are vast and far-reaching. It has a profound effect on every aspect of our lives, from how we engage with one another to how we manage or resolve any form of conflict that arises as a result of those interactions. In the field of alternative dispute resolution, the information age has truly revolutionized ADR mechanisms into more inclusive, and effective channels for justice administration. As a result, the Department of Justice's Office for Alternative Dispute Resolution has consciously designed the National ADR Convention this year to cast a spotlight on the world's ongoing digital revolution. Throughout the event, you will be exposed to insightful discussions on ADR topics such as the growing interplay between digital commerce and online dispute resolution. In 2016, the UNCITRAL Working Group 3 on ODR finalized the non-binding technical notes on ODR, reflecting the elements and principles of an ODR process. The group undertook extensive research on cross-border e-commerce transactions in order to develop a set of procedural guidelines for ODR. And I am honored to inform you that we have invited experts directly from UNCITRAL, international arbitration committees, and consumer commissions to share first-hand observations and perspectives, particularly on emerging ODR challenges and developments. The discussions on international instruments and experiences are instructive in light of recent local gains on ODR, such as the Internet Transactions Bill, which is currently being deliberated in the House of Representatives, guidelines on arbitration for intracorporate disputes, which are presently being formulated by the Securities and Exchange Commission, and the implementation of an integrated national ODR system for consumer protection, which is actively being developed by the Department of Trade and Industry. We will also hear from our Philippine partners from private and public sectors on a variety of ODR concerns, including the distinctive features of local electronic commerce disputes, the establishment of institutional frameworks, the drafting of agreements, procedural standards, and enforcement. They will also offer insights on the major impediments to the future development of Philippine ADR and ODR, such as the necessity for mass information dissemination and a perceived lack of enforceability mechanisms for agreements and awards. Most importantly, we will hear recommendations on how to improve the design and operation of ADR and ODR systems in our respective organizations. These recommendations will help us improve our present processes and guide us shape our future efforts toward the new normal. Finally, I believe that ADR and ODR will continue to grow in acceptance and recognition as efficient and effective conflict resolution mechanisms in the years ahead. And I urge you, my fellow ADR advocates, to support the Office for Alternative Dispute Resolution in ensuring a sustainable and constant development of ADR in the Philippines for our people and the world. Again, let me express my sincerest gratitude to all of you. Welcome to the National ADR Convention. Good morning.
Thank you very much, ED Irene, for welcoming us all to the second day of the NADRC 2021. Due to an unforeseen event, our keynote speaker will not be able to join us today. However, we would like to express our sincere gratitude to the UNCITRAL for their unending support to the OADR and this convention. We now proceed to the program sessions, featuring the topic on ADR digital transformation, the online dispute resolution. To help us understand domestic and international online dispute resolution, let me introduce to you our first speaker, Ms. Caroline Nicholas. Ms. Caroline Nicholas is the Head of Technical Assistance Section and Senior Legal Officer at the International Trade Law Division, United Nations Office of Legal Affairs. She has previously served as Secretary to the UNCITRAL's Working Groups 1 and 3, leading UNCITRAL's work on procurement and infrastructure development, investor-state dispute settlement, and online dispute resolution. Caroline also teaches and publishes on the UNCITRAL matters in public procurement law and policy at the postgraduate level in several UK and European universities. Prior to joining UNCITRAL, Caroline was an investigator in the United Nations Office of Internal Oversight Services, handled Kuwaiti government claims at the United Nations Compensation Commission, and practiced as solicitor in commercial law and commercial litigation in the city of London and Hong Kong. She has master's degrees in philosophy, politics and economics, and public procurement law and policy. Ladies and gentlemen, let us all welcome our first speaker, Ms. Caroline Nicholas.
Greetings from the UNCITRAL Secretariat in Vienna. It's a great pleasure to be able to talk to you today, albeit digitally, thanks to the COVID pandemic, about how the world is digitizing and transforming ADR, and more specifically, how UNCITRAL took up the challenge of enabling online dispute resolution. You've heard from my colleagues Jae Sung Lee yesterday on UNCITRAL's expedited arbitration rules, and from the UNCITRAL Secretary, Anna Joubin-Brett, on UNCITRAL's work in digitizing ADR more generally. But I'd like to start, before I turn to ODR, with a little bit of history. So over the last 20 years, UNCITRAL has had a major focus in this area, moving from what was then called e-commerce and was then in its infancy, until now when it's leading up the UN's work in setting legal standards for business in the digital age. UNCITRAL's e-commerce instruments, starting with e-payments, moving through e-commerce, e-signatures, and most recently e-transferable records, that's bills of exchange, bills of lading and the like, have been particularly welcome and used in the Asia-Pacific region. Most states in the region, including the Philippines, have already adopted at least one or more of UNCITRAL texts in this area, and more states are expected to follow. The texts themselves are also benchmarked in free trade agreements because they enable cross-border e-commerce and digital trade. For example, the Regional Comprehensive Economic Partnership recommends states parties to adopt or to maintain a domestic legal framework for electronic transactions that's based on UNCITRAL texts. And we are of course aware that commercial transactions inevitably involve disputes in some cases. So we need rules that apply across different systems and that reflect contemporary business practices, including those associated with the platform economy, not just about building contracts, but dealing with the inevitable problems in their execution. And here we need to think particularly about small businesses with small contracts across borders, and to place their needs at the forefront, because the size of these contracts related to the costs of traditional dispute resolution systems simply don't work. Now, we're aware that some large platforms, think of Alibaba, eBay, Amazon, and PayPal, have built-in dispute resolution systems as add-ons to the sales or the payment platform, but others do not, and that's where UNCITRAL's rules on ODR had their beginnings, that is, providing a system for those outside those major platforms. I'd also like to emphasize that the reason that UNCITRAL texts work is because they are based on an examination of the legal obstacles to cross-border commerce and on finding a practical solution to those problems, and a practical solution that addresses the needs of businesses of all sizes. It turns that practical solution into legal rules, and UNCITRAL texts can take the form of conventions, model laws, legislative guides, and so forth. And if they're to be successful, not only do they need to work in all regions and at all levels of development, but they really do need to be grounded in practice. The legal rules themselves are negotiated in intergovernmental sessions in UNCITRAL, and it's this active sharing of practical experience from all regions that allows the system to work. And here I'm delighted to note that the Philippines is an active participant in our work. UNCITRAL has also taken note that future work on legal issues related to the digital economy could assist efforts to bridge what has been termed the digital divide, and it's this spirit, consistent with the Sustainable Development Goals, that's guiding additional and preparatory work that we're undertaking in such areas as artificial intelligence. So turning to the ODR system in UNCITRAL itself, first a little bit of background. So it was in 2010 that we decided to undertake work in online dispute resolution. And it was against the background of a sharp increase in online cross-border transactions and the need for an efficient, low-cost and simple resolution system. And part of the motivation here was to resolve differences and enhance trust in e-commerce, and so that would enable cross-border trade and e-commerce to flourish. And I mentioned earlier on the importance of these rules for smaller businesses, and this is because their contracts are likely to involve relatively low values, they're particularly sensitive to time and cost issues, and the opportunity cost of litigation or even arbitration is extremely high. So let's just explore a little bit the concept of opportunity cost of litigation and why it's such a problem in terms of international cross-border commerce. So the obstacles to the traditional resolution of disputes that I've set out on this slide are essentially that they are long, they cost a lot of money, and they're difficult to fathom. So what does that mean? The skills of the entrepreneur, who is an entrepreneur because he's good at business, are diverted into trying to work his way through court systems, and very similar for arbitration. And a small business is unlikely to have a specialist in a dispute settlement or litigation department, so it will generally be the head of the business that gets whose attention is diverted in this way. But even should they get through the court system or an arbitration system and get a judgment or an award against a business in a different jurisdiction, how's it going to be enforced? The recognition and enforcement of judgments in another jurisdiction is fairly difficult and also costs money. And the same point applies to arbitration. In many ways, there are systems that will enable you to do it, but they are extremely expensive. So for this reason, traditional resolution of disputes in small value cross-border transactions is simply not cost effective. And this was UNCITRAL's starting point. So having looked at some of the difficulties that would confront particularly a small business trading overseas, what did UNCITRAL decide to do? Well, it noted the potential of an online dispute resolution system. It noted the potential of low-cost, simple resolution of disputes, and that would enhance trust in e-commerce, particularly where these sales were going on through platforms without their own dispute resolution mechanism. And enhancing that trust would enhance cross-border trade and e-commerce. And in terms of context, UNCITRAL thought particularly about the fact that the contracts were likely to involve relatively low values, that the businesses would be particularly sensitive to time and cost issues, and that the ODR platform, so an ODR platform would be designed as a technology-based intermediary, very importantly, so that the whole process could be done online. Now, UNCITRAL's initial approach was that it would provide procedural rules for online dispute resolution and guidance on how to use them. And the context would be this low-value environment, but also what it called a high-volume environment, meaning the sort of disputes that would occur often. And generally in cross-border commerce of the type that we're talking about, that means failure to deliver on time, failure to deliver in terms of exactly what was ordered, or failure to pay. So there's a relatively simple number of issues that arise. And two specific points that were considered was that the platform would cover not only business to business, but also business to consumer disputes. And it would also include a cross-border mechanism to enforce ODR decisions, so the eventual decision in favour of one or the other party. So returning to a point I made at the beginning, that UNCITRAL considers things from a factual perspective and then goes on to design rules. The ODR process that was decided upon was represented by 3 stages that one would expect to see in trying to resolve a commercial dispute in a practical way. The first is to allow direct negotiation between the parties where any misunderstandings could be corrected. The second is that if those negotiations don't succeed, that there should be an intermediary who could try and facilitate a settlement. And if that doesn't work, then there would be a final stage where there would be a determination in favour of one or the other party or some other form of decision. So that was what UNCITRAL wanted to do. And a couple of key issues involved, or the main key issue in fact, was the form of the final stage. Now I mentioned a moment ago that the scope of the system included both business-to-business and business-to-consumer transactions. And here, recalling the very important aspect of UNCITRAL, that its texts should be able to operate in all regions and in all systems, we came up against an issue which is the different approach to consumer protection in different systems. And that was very much on display when discussing the final stage. The first was, should the final stage be binding, as arbitration would be, or a non-binding recommendation that allows court action? Now, we don't have time today to go through what that means in essence, but consumer protection systems in some countries do not allow consumers to agree to a binding dispute resolution such as arbitration before the dispute arises. And these issues made it very difficult to agree on one single form of a final stage that would be recommended in UNCITRAL. So as a result, we had to come up with an alternative system. So as I said, we had to come up with a different approach. So eventual resolution was to decide not to be prescriptive about the final stage of the process. And because of that, instead of issuing rules, we issued technical notes on ODR, and the key characteristics are set out on this slide. So it's a non-binding document, and it describes the process of ODR and reflects on the major elements that process should involve. And so it's a tool for countries to use domestically. It addresses all the three stages of the process, but leaves the final stage to different economies or countries to address, and reflects those different approaches that I talked about earlier on. It also explains something that's very novel, and that is the powers, the roles, and the responsibilities of the different elements of the system. That's the platforms themselves, the administrators, and the neutrals. And the neutrals are those people who may facilitate settlement. And it also sets out the steps that actors are supposed to take. This is an extremely important set of issues to discuss in the low value context, because one of the motivations is was the notion that comprehensive and traditional dispute resolution processes would be completely unsuitable for this environment. And you'll see here a link to the UNCITRAL online dispute resolution website, and here you will find the technical notes themselves, a small history, and a discussion page under additional resources where you can see how the texts were put together, and additional online resources and webinars. And it's very important to note here that the documents under working group under additional resources will explain to you some of the other legal issues that we considered: a dispute resolution clause, questions of applicable law, and practical questions like language and what legal principles might be applied. Some technical issues, confidentiality, data protection, and some other issues such as minimum standards for ODR providers and the costs of the process. Now, these are alluded to in the technical notes, but they're explored at a theoretical level, i.e. at a brainstorming level, in the additional resources documents that you can see here. And for those of you who are interested in the theory of how UNCITRAL develops its work and why it does what it does, we do invite you to take UNCITRAL's first online training course, which is an introduction to UNCITRAL, that was launched in July this year. It's been developed in collaboration with the International Training Centre of the International Labour Organization, and it's an interactive and self-paced course which introduces users to legal harmonization, UNCITRAL and how it works, and UNCITRAL and the SDGs. The modules are available in English and in Chinese, and the first three modules are the first in a series, and an electronic certificate is downloadable for the platform for all users who complete all three modules. It's free of charge, and users will be able to enroll in a course on e-commerce in the future. And talking of the future, UNCITRAL may return to ODR, and we hope that the concept of more technically assisted dispute resolution systems and the greater use of ICT in traditional court systems and enforcement mechanisms through ODR will come back on the UNCITRAL agenda sometime soon, because as e-commerce and the digitization agenda proceeds, so UNCITRAL's technical notes will need to be updated. So in closing, I'd just like to draw to your attention once again that further information on the technical notes is available at the web link shown here. I hope you can read it despite the slightly odd colour. I'd like to thank you again for your attention and to emphasise that any requests for further information on ODR and the UNCITRAL approach to this important topic is available through the website. We have uncitral@un.org as a generic email address, or you can contact me at caroline.nicholas@un.org. Thank you very much, and I wish you great success for the rest of your conference.
Thank you very much, Ms. Caroline Nicholas. For our next speaker, we have Singapore International Arbitration Registrar, Mr. Kevin Nash. As a registrar of the Singapore International Arbitration Center, Mr. Kevin Nash oversees the SIAC Secretariat in the provision of case management services and the supervision of SIAC's multinational secretariat. Over the course of the past decade, Kevin has overseen the administration of thousands of international cases under all versions of the SIAC rules and the UNCITRAL arbitration rules. Kevin is a member of the Singapore delegation at UNCITRAL Working Group 2 and represents SIAC at UNCITRAL Working Group 3. He is listed by Who's Who Legal as one of the leading arbitration lawyers in the Southeast Asia and a future leader in the Global Guide. Kevin is a qualified as barrister and solicitor with the Law Society of Upper Canada. He speaks English and French. Ladies and gentlemen, let us all welcome Mr. Kevin Nash.
Good morning. Thank you to the Office for Alternative Dispute Resolution of the Philippines for inviting me to speak at the National Alternative Dispute Resolution Convention on Justice in the Digital Era, where we look at the synergy of traditional ADR and technology. For my part, I very much miss traveling to the Philippines, and hopefully we will all be able to meet in person soon. In fact, it seems like not too long ago, we were all having dinner with one of our co-panelists today, Prof. Valderrama, in Manila. The Philippines is, of course, one of SIAC's most frequent users. We have a lawyer qualified in the Philippines in the SIAC Secretariat, Thea Vega, and the head of SIAC's Americas office in New York, Adriana Uson, is also from the Philippines. In fact, we have such a long history of staff from the Philippines in SIAC that I do have a passing knowledge of Tagalog at this point. Most of my experience and the experience of SIAC involving parties from the Philippines would involve major projects, some arising out of build. But we are also seeing an increasing number of tech disputes arising out of ICOs, and disputes where there's a call for an online element. Singapore has also recently updated its legislation to provide for the arbitrability of certain types of IP disputes. Let's start with the good news. The marriage of online dispute resolution and traditional ADR is working. Arbitration has adapted and the practice is better for it. There are also some very exciting developments with sets of rules for domain name disputes arising out of electronic commerce, and the possibility of blockchain arbitration and full ODR with modifications to ensure international portability under the New York Convention. Philippines may be particularly well placed for ODR going forward as the Philippines continues to increase its connectivity and mobile internet speed in the ASEAN and global rankings. So let's look at the demand for some form of ODR in the arbitral process, and I'll be examining this from an international perspective. In the 2021 Queen Mary University of London White and Case survey, the top ranked choice for adaptations that would make institutions or rules attractive to users was administrative and logistical support for virtual hearings. And an overwhelming majority of the respondents would choose to proceed at the scheduled time at a virtual hearing rather than waiting for a hearing in person. The flexibility to proceed online or in hybrid form has been particularly important in 2020 and 2021, as these have been the two busiest years on record for institutions, particularly in Asia. In fact, if you look at the aggregate caseload in the sum and dispute from SIAC, HKIAC, and KCAB, it would rival the numbers for any institutions. But the past years have been about more than just case numbers. As we all know, arbitration is the grease on the wheels of the global economy. At no time has it been more important for arbitration to be able to adapt quickly and with nimbleness, and online dispute resolution has been at the center of this. If I look back on the SIAC experience, turning back to the 3rd of April 2020, Singapore announced a nationwide partial lockdown known as the circuit breaker. Dispute resolution paused for a few minutes and perhaps a few hours, and then all of the institutions, including SIAC, were able to implement an online experience to keep these disputes being resolved. Once the duration of the pandemic became more clear, the choice for parties was whether to pause and kick the can down the road and wait till we could proceed in person or proceed in an online form. And arbitration as a practice was very well suited to be able to proceed with some form of online dispute resolution. Now, most of the institutions have some form of telecommuting. Everyone is using online case management systems. Documents are being filed online, and many hearings are being conducted virtually. Institutions such as the Stockholm Chamber of Commerce have platforms when the entire arbitration can, in effect, be conducted online. The SIAC online experience is similar, with more and more parties opting to proceed in some form of online dispute resolution. And the future of arbitration must surely capture the possibility of e-filing, online filing of the notice of arbitration, electronic document management, and finally the e-transmission of the award, potentially with an e-signature, as we see in the 2020 LCIA rules. Even before the pandemic, leading thinkers such as Singapore's Chief Justice Sundaresh Menon had advocated technology adoption, having spoken several times over the years about the importance of the legal profession adopting the use of technology in its day-to-day work. And that time is certainly now. Leading organizations have responded with a flurry of scholarship to push the boundaries on traditional ADR and see how we can all leverage online technology to remain faithful to the fundamental principles of arbitration. SIAC released a guide on taking your arbitration remote, which functions as a checklist for parties and arbitrators to use prior to a virtual hearing. There's the Seoul Protocol on video conferencing in international arbitration. ICC has a guidance note, as well as HKIC, LCIA, SCC, ICA remote hearing guides, CIARB has a guidance note, the Delos checklist. These are all designed for us to adapt to online dispute resolution. Now, looking back at the SIAC experience over the past 20 months, and because of the way the COVID-19 pandemic has been handled in Singapore, the majority of hearings were handled by virtual means. This might be through Microsoft Teams, Zoom, WebEx, BlueJeans, Skype, using Maxwell Chambers virtual ADR services. But in Singapore, we also had hybrid hearings, and this may well be the way forward. It could be the case that the case management conference would be handled virtually, interlocutory applications would also be handled virtually, and then there may be the evidentiary hearing in person. Now, we all know the challenges or issues with online dispute resolution, particularly for full ADR, whether there is a seat of arbitration in blockchain or smart contracts, whether there's an agreement in writing, and looking at the potential for international enforceability. When we're looking at this juxtaposition of traditional ADR and ODR, the most common form that we see is virtual hearings. So then parties and arbitrators need to be mindful potentially of asynchronicity. How do we balance time zones? Asymmetric hearings where certain parties may be in person and other parties are participating virtually. We need to look at whether the lex arbitrii has an express or an implied right to a physical hearing and what the institutional rules say. In the SIAC rules, the tribunal is given very broad powers to conduct the arbitration in a way that it sees fit. And Schedule 1 of the SIAC rules also contemplates the possibility of hearings by video conference. Parties have had to adapt and look at the potential for witness coaching, whether witness testimony can be given remotely, and the applicable law, whether it allows the remote taking of oaths. Overall, with virtual hearings, it is a must to ensure the integrity of oral evidence, potential ex parte communications with the tribunal. This may take the form of having 360 cameras for witnesses, having the witness display documents and witness statements that she's referring to, sealed envelopes, clean tables. One thing that institutions have all been working on is data protection and cybersecurity, maintaining the sanctity of this information, recognizing our role as data controllers and appreciating the amount of data that we're controlling alongside our confidentiality obligations. There's also practical considerations on the conduct of the room. We hear some counsel saying that they need to know the feel of the room, to see the whites of the witnesses' eyes, whether or not in a virtual hearing you can get both the micro and macro perspective. From a tribunal dynamic standpoint, there's the question of whether there may be more dissents without tribunals able to meet in person and witnesses' performance in the arbitration box when they're participating virtually. We also need to be mindful of the language of the arbitration clauses, and to borrow to a certain degree from the 2020 VIS moot problem, what happens to arbitration clauses when they provide for arbitration hearings to be held in Singapore in the arbitration clause? Will this allow the possibility of a virtual hearing? And overall, there needs to be thought given to observation of due process and natural justice issues through the course of the proceedings. Tribunals should carefully monitor the proceedings to ensure that the party's right to present its case has not been jeopardized. We know from recent jurisprudence in Singapore that a full opportunity to present one's case should be interpreted as a reasonable opportunity. We also see with virtual hearings that perhaps there's a streamlining of submissions that will help reduce the time and expense of arbitrations. Tribunals may reduce or limit post-hearing submissions, and witnesses may be able to be recalled for limited cross-examination if there's a technology failure during a particular segment of the virtual hearing. Now, looking at it from SIAC's part, complex and high-value disputes will remain the province of traditional alternative dispute resolution. However, with traditional arbitration increasingly incorporating modern technology into its proceedings, the distinction between online arbitration and traditional arbitration is becoming less clear. We are at the inflection point or a moment of disruption. The lawyers, institutions, and jurisdictions that can capture online dispute resolution and incorporate it and juxtapose it with traditional ADR will become the leaders of tomorrow. And if we think about it from an arbitration standpoint, everything that we're doing in our institutional rules and with the adoption of online dispute resolution is to remain faithful to the fundamental principles of arbitration. And arbitration can, in fact, be better for it when we adopt these online dispute resolution principles. The reason why arbitration is overwhelmingly the preferred choice for cross-border transactions is because arbitration is fast, it's cost-effective, it's efficient, it's fully customizable. You get to choose your decider, confidential, limited avenues of appeal, international enforceability in 168 countries. This is what online dispute resolution can give arbitration. We are also seeing an increased call for green arbitrations. And so we are becoming much greener by not having to fly around the world to conduct these arbitrations. If you imagine it from an SIAC arbitration, if we were looking at a high-value, multi-billion-dollar dispute, we may have a 3-member tribunal with an arbitrators located in Manila, Tokyo, and Vancouver. Instead of all of those arbitrators flying off to Singapore and having to balance the busy diaries of these arbitrators, these proceedings can now be held online. So online dispute resolution, if it is properly leveraged, can make arbitration more efficient. And if we look at the emerging sectors of tomorrow with an increased amount of fintech going to arbitration, we see that we will need to adopt some of these procedures. From SIAC's part, we now have all of our initial pleadings are being filed online. We have the full secretariat that is working both in the office and also telecommuting. We are able to use our case management system to be just as efficient as we were when we were acting in person. And when it comes to the transmission of awards, we will first provide an electronic copy, but we will also transmit the physical copy of the awards to fit with any requirement in the potential enforcement of jurisdiction for a wet ink signature. When I look at it from my part as an arbitration practitioner for SIAC and for arbitration more broadly, this is one of the most important times for arbitration. So we are continually and constantly looking at ways to incorporate online dispute resolution into the SIAC case management experience. And we are looking forward to working with our stakeholders and friends in the Philippines, other institutions and jurisdictions across the world to incorporate this technology. Thank you very much, and I'm very happy to be here today.
Thank you very much, Mr. Kevin Nash. More about understanding online dispute resolution mechanisms, we have our next speaker, Professor James Claxton. Professor James Claxton has 15 years of experience in international dispute resolution as arbitrator, mediator, and attorney. Apart from practice, James is professor of law at Waseda University in Japan. His recent publications appear in the Asian Journal on Mediation, the Journal of World Trade, and the Pepperdine Dispute Resolution Law Journal. James began his career as an attorney with law firms in Paris and as a legal counsel at the International Center for Settlement of Investment Disputes of the World Bank in Washington. Ladies and gentlemen, let us all welcome Professor James Claxton.
Well, let me begin by thanking the Office for Alternative Dispute Resolution for the opportunity to participate in this second online National Alternative Dispute Resolution Convention. The focus this year on digitalization and online dispute resolution could not be more timely or appropriate. I have been asked to provide an overview of good practices in online mediation. In this spirit, I would like to suggest 3 guiding principles for online mediation, and then provide some thoughts about how these 3 principles can be realized in practice. Digital evangelists have told us for more than a decade that the future of ADR is online. The COVID-19 pandemic has thrust us into the future they imagined. Mediators and parties with no online experience have been propelled, sometimes kicking and screaming, into the virtual world. This move online has highlighted the comparative advantages of online mediation. Many who had doubts about online mediation have now joined the ranks of the evangelists. Put simply, online mediations are easier to organize and easier to convene and reconvene. They avoid wasted time and expense spent traveling to physically join mediations. Other advantages have come to light that may be less obvious. For instance, it may be possible for decision makers who are more senior to join mediations online than in person, which could improve chances of settlement. Parties may be more relaxed when joining mediations from their homes and offices, which may create a better atmosphere for dialogue than a conference room in a hotel in an unfamiliar city. It may also be easier for third parties, such as witnesses or experts, to participate in mediations. With these thoughts in mind, allow me to suggest 3 principles for better online mediations, drawing on the experience of more than a year of widespread use of online mediation. The principles are foresight, flexibility, and fairness. I'll say a few words about each from the perspective of mediators, but the principles are equally relevant to disputing parties. First, foresight. What I mean by foresight is that mediators should think through problems that might result when a mediation is held online and take steps to avoid them. While preparation is important to any mediation, preparation for online mediation requires some additional steps. Mediators should advise parties about technological aspects of online mediation early in the process. This includes explaining the features of the online platform that will be used and meeting the parties online to demonstrate these features. Mediators should also test the parties' connections and the functioning of their equipment. This might seem obvious, and it is certainly true that we are all now used to navigating video conferencing platforms. Even so, some features used in mediations may be less familiar, including breakout rooms, whiteboards, and certain privacy features. Mediators can also advise parties about how to use technology to their advantage to communicate more effectively. This might be thought of as the personal side of technology. Camera angles, lighting, and the volume of speakers' audio can all impact the effectiveness of communication. Attention to these details may help parties to feel more prepared and more confident. The selection of the physical space from which the parties join the mediation is also important. An appropriate joining space will be comfortable and private with a minimum of environmental distractions. Mediators should also exercise foresight in other ways. Such as building relations with parties. Some mediators complain that it is harder to build trust with parties online than in person. Some research suggests that there may be no real difference in building relations online, except that trust may take longer to achieve online than in person. This implies that where possible, mediators should spend time with parties before a mediation starts. The second principle is flexibility. Many constraints on physical mediations don't exist online. A mediation in person requires that the parties and mediator meet at the same physical location at the same time. The need for a physical meeting impacts the cost of mediation, the dates available for the mediation, and maybe even who participates in the mediation. Mediators should use the flexibility of online mediation to their advantage. Online mediation might work well as a one-day event with all parties present at the same time. Or online mediation might work better as a series of short private meetings with parties over several days. The relative ease of joining online mediation sessions makes it possible to tailor the process to the needs of each dispute. The third principle is fairness. Online mediations raise fairness concerns that do not exist in the same way in physical mediations. This feature of online mediation requires more planning. Mediators should take special steps to ensure privacy and confidentiality online. For instance, parties should be advised not to join mediations from physical spaces where the proceedings can be overheard by third parties. Fairness issues may also arise where parties are far apart. Where parties are in different time zones, mediators should try to find a time for the mediation that is convenient for all parties, or at least that is not any more inconvenient for one party than the other. Fairness is also linked to the ability to communicate. Parties with better internet connections and fewer environmental distractions may be able to communicate more effectively. Mediators may be able to address these problems before the mediation. Fairness also means that the parties have equal access to the mediator. This may have particular resonance in hybrid proceedings, where one party is physically present and the other is not. A party who is distant from a mediation may feel that they do not have the same access to a mediator than the other party, and this may impact their perceptions about neutrality and the legitimacy of the process. Mediators might therefore think twice before agreeing to hybrid mediations, or they may otherwise take special care to advise the remote party about measures taken to assure equal treatment. Allow me to conclude with 4 concrete steps arising at each stage of a mediation that mediators can take to realize these principles of foresight, flexibility, and fairness. First, mediations normally begin with the conclusion of a mediation agreement between the mediator and parties. it may be useful for mediators to provide two additional instruments. The first instrument is a guide to online mediation. The guide can explain the mediation process, including technical aspects, so that parties are better prepared for online mediation and know what to expect. The second instrument is an online conduct agreement for mediation that formalizes the responsibilities of the mediator and the parties. This agreement can include, for instance, commitments by the parties not to record the mediation, to use secure internet connections, and to promptly advise the mediator of any technical problems that may occur during the mediation. Commitments like these may make the process smoother and may help to ensure the viability of any settlement agreement that results. The second concrete step that mediators can take in furtherance of the principles is to meet each party individually online before the mediation. These meetings are an opportunity for the mediator to discuss the online mediation process with the parties and to put them at ease about technical aspects. The mediator can also use the meeting to discuss the substance of the dispute with each party. This should improve the mediator's understanding, but also help to build the trust of the parties, which, as discussed, may take more time online. The third concrete step that mediators can take is to monitor the impacts of technology during mediations. Mediating online for long periods of time can be tiring. Mediators may decide to take more breaks or to hold shorter sessions than they would in person. Technology can interfere with communication in unexpected ways. Research at the Stanford University Virtual Human Interaction Lab suggests that seeing video feeds of our faces can be distracting and even stressful. There have also been studies showing that body gestures and eye contact are perceived differently online than in person. Based on these findings, mediators may decide to take camera breaks during parts of mediations or to encourage parties to turn off the self-view feature of their video feeds. The fourth concrete step is to meet with the parties online after the mediation. If the mediation did not settle the dispute, this online meeting is an opportunity to discuss what further steps might be possible. If the mediation led to settlement, the online meeting can be used to get feedback from the parties about their experiences online, which can be used to improve the process in the future. In either case, the relative ease of arranging online meetings should facilitate this follow-up session. To conclude, by keeping the principles of foresight, flexibility, and fairness in mind, mediators and parties can get the most out of the online mediation experience. With that, I thank you for your attention.
Thank you very much, Professor James Claxton. To continue with our session on ADR digital transformation and online dispute resolution, we have Attorney Nathaniel S. Arevalo, Director of the Bureau of Legal Affairs of the Intellectual Property Office of the Philippines. Ladies and gentlemen, let us all welcome Attorney Nathaniel S. Arevalo. Arevalo, Attorney Arevalo, can you check your microphone? We cannot hear you.
How about this? Do you hear me now?
Yes, sir.
Okay. Okay. So good morning to all esteemed speakers, participants, and viewers. First of all, I would like to congratulate the DOJ OADR led by Executive Director Attorney Irene Alogok for successfully organizing the second National ADR Convention, which started yesterday. On behalf of our Director General, well as Barba and the IPO Phil organization, we convey our gratitude for giving us the opportunity to participate in the convention and share in 15 minutes IPO Phil's experience in the area of ADR, particularly online dispute resolution. Uh, as a backgrounder, the mandate of the IPO Phil, which is relevant to the ADR, is laid down primarily in Section 10 of the IP Code as amended. The IPO Phil's adjudication arm is the Bureau of Legal Affairs, which is my bureau. The BLA hears and decides two categories of class of cases or disputes. The first one is inter partes cases, which includes opposition to trademark registration, cancellation of trademark, utility models, and industrial design and patents. The second category is IP rights violation cases, which is IPR infringement, unfair competition, false designation of origin, and or declaration infringement of trade name and business name. IPOPhil has an existing ADR program pursuant to uh, Republic Act 9285 or the ADR Act of 2004. We particularly implemented mediation arbitration. The objective is to give parties in dispute an opportunity to choose an alternative mode of resolving their disputes that could be faster and less costly for them. The ADR complements the mandated adjudication mandate of the IPOPhil. In this regard, the BLA administers or manages the ADR program. Our ADR includes mediation arbitration, but for this presentation, I will focus on mediation since we are still re-engineering our arbitration process. Our mediation evolved through the years. We started with the mandatory referral of cases filed in the IPO field, uh, but the parties, however, may refuse to submit to mediation proper. In October 2018, we shifted to mandatory mediation. But of course, the parties are not compelled to enter into a settlement agreement. In 2019, we opened up mediation outside litigation services, where parties in dispute over IP may request or submit to IPO field for mediation without the need of filing first a case in the IPO field. Significantly, on November 16, 2020, the DOJ OADR issued its accreditation of IPO field as a public mediation provider, becoming the first and only government agency so far to be accorded by such recognition. So thank you again, OADR. Uh, at the end of November this year, the total number of cases that have actual undergone mediation proper is 1,714, and 650 of those cases reach an amicable settlement, which represents 37.9 settlement rate. Admittedly, we have not anticipated the rapid onslaught of the COVID-19. Never did we imagine that the Philippines will be subject to drastic measures such as lockdown when the enhanced community quarantine ECQ was first imposed from March 16, 2020 to May 15, 2020. The IPO field issued regulations providing guidelines for the continued delivery of its services. However, under Memorandum Circular 2020-11, all hearings, including mediation, were suspended up to May 15, 2020. Then came the extensions of the ECQ. Thus the questions: how are we going to deliver our mediation services in the face of the difficulties and restrictions imposed as regards to travel, mobility, hearings, meetings, conferences, and physical contact? Furthermore, the skeletal force in government offices will reduce the barest minimum, at most 30% of the total number of personnel complement. So we were inundated with queries and requests for clarifications and advice as to when will mediation resume. Our response is to adopt an online mediation. After weighing all the possible options and consultations with the mediators, the BLA recommended to the Director General the adoption of online mediation if IPOFL wants to ensure continuity of delivery of mediation services. The proposal was anchored on two consideration factors. The first one is the use of available information and communication technology, virtual meeting platforms to transform negotiation from in-person format to online, and also to facilitate communication. There is also the need to pursue a more tedious process. There is also no need to pursue a tedious process of amending the existing rules. We exploited or we took advantage of the window opportunity under the rules of mediation, which says that upon the request of both parties, the mediation may be conducted at any other venue as may be agreed upon. So the BLA considered cyberspace as a form or in the nature of venue for mediation. Online mediation has been part of the BLA's or the IPO Phil's long-term plan to modernize and automate the adjudication and dispute resolution functions. Ironically, the pandemic fast-tracked our implementation of online mediation. On May 4, 2020, we implemented Memorandum Circular 2020-012, which says that parties were given the option of requesting the holding of virtual mediation in lieu of face-to-face or physical presence in the IPO field. No additional, however, was required, while all notices and communications were to be made via email. The parties' response to the measure was favorable. A request for online mediation poured in, exceeding our expectations. By the end of 2020, almost all of the mediation, including the preliminary meetings, were conducted virtually. There was a clear indication that parties are willing and, in fact, have accepted online mediation. The results of the customer satisfaction survey conducted in 2020 showed that mediation service gathered from the users a 100% satisfaction ratings, mainly because of the measures adopted, ensured continuity of services during the pandemic. Online mediation yielded positive outcomes such as the following. It eliminated and minimized risk or dangers to health during the pandemic. Less expenses, costs, and stress to the parties, counsel, and mediator. The parties and the mediators can stay at their respective offices and homes. No travel expenses and incidental expenses, including parking fees, are needed. It encouraged participation of principals based or residing abroad. It allowed greater accessibility to mediation. It facilitated sharing of documents. Personal touch is maintained between and among the parties and the mediators. Confidentiality of the proceedings is ensured, thereby ensuring trust in the process. And the chance of settlement was not actually diminished. From May to December 2020, 31 out of 98 cases mediated online were settled, which amounted to represents 31.6%, which is approximately almost the same as in the traditional mediation. Riding in on the momentum, and highlighting the fact that the acceptance by the parties, the BLA recommended that online mediation be mandatory. Thus, in March 2021, IPO Phil's mediation services became 100% online through Memorandum Circular numbers 2020-47 and 2020-48. The salient features are the following. Referral or request for mediation shall be filed or submitted via email. All notices and communications shall be sent via email. Payment of fees shall be made to the IPF's online payment facilities, and all meetings and sessions, including pre-mediation briefings, are virtual. There are no additional fees. Based on our experience in implementing online mediation, we deem that the following are very important for the parties, the mediators, and the service provider. Invest and maintain a stable internet connection. Ensure the availability of facilities for online mediation, including virtual meeting platforms. The parties must be committed, willing, and are comfortable to participate in the virtual or online proceedings. And the last one is the catch-all guidance. Ample preparation must be made by all concerned before the mediation. We believe that online mediation or online ADR should be promoted and considered as an option, if not the primary one, to go along with face-to-face or in-person process. The online mediation or ADR ensures resiliency and provides flexibility thus adapting to any contingencies such as the current pandemic. The use of virtual mediation will continue to be developed and promoted. Technology-based and innovative processes will continue to evolve to enhance the environment suitable to resolution of disputes. Confidentiality is ensured. Practicing and would-be mediators ADR must enhance and or develop competencies that would enable them to adapt to the new way of doing things. With that, I end my presentation. Thank you.
Much Attorney Nathaniel Arevalo of the Intellectual Property Office of the Philippines. For our next speaker, we have the General Counsel of the Construction Industry Arbitration Commission, or CIAC. Ladies and gentlemen, let us all welcome Attorney Mario E. Valderrama.
Thank you for that nice invitation. And may I express my gratitude to the organizers for including the CIAC in this presentation. I can't seem to I can seem to have the slides here. Okay, so can you see the slides, please? Nawala. Hello?
You can see the slides.
Yeah, the slides are, can you see the slides?
Yes, sir.
All right, so we may as well go ahead. Anyway, so we will be talking about the CIAC approach on the ADR dispute transformation and in the online dispute resolution. Now, just some background there. The Philippine Supreme Court characterized CIAC arbitration as a hybrid, but its very nature as an arbitral tribunal effectively places it at par with other commercial arbitral tribunals. And this would be in the cases of Global versus Ross and Ross versus Global. Now, CIAC or the CIAC is the Philippine Construction Industry Arbitration Commission. And in the Philippines, I can say that CIAC was the most, or is the most successful so far institution. And the CIAC has so far succeeded and hopefully will continue to succeed in attracting and keeping local construction disputes within the Philippines. Now, the descriptive words on the CIAC approach would be the following: we adapt and we adapt. Of course, we create, we can innovate, and there is flexibility in the adopted approach. Now, CIAC is not a stranger to the use of technology. Several years ago, a CIAC tribunal conducted a hybrid proceeding. Now, the witnesses were in Singapore. Let us not discuss anymore why they cannot come to the Philippines. And we used at that time Skype. Of course, we have to look for compatible apps here in the country, and it went well. So, but of course, there were some technical snags. Now, before Zoom and similar apps, CIAC conducted a hybrid maze. It is its version of the MCLE and CPD for accredited arbitrators based in the Visayas and Mindanao, because the accredited arbitrators of SIAC is or are not confined to Metro Manila. And more than a year before the advent of Zoom, a lecturer already suggested the possibility of doing proceedings remotely, as shown in the succeeding slide. So this was the slide then at the time, and so exchanges by email, signature by segments, oral evidence via video link, and of course we have documents and pleadings to be served on CD, USB memory stick, or Microsoft Word searchable, editable PDF format. Where practicable, hyperlinking any reference to documentary evidence, pleadings, case law, experts' reports, and witness testimonies to that reference. And most of these were actually now incorporated in the current approach, no? Except that we now have Zoom. So it was quite easy then for CIAC to transform to virtual proceedings. And as of this date, I could say that CIAC has proven capacity to handle virtual proceedings. Now, after once the effects of the pandemic were being felt, now your commission or CIAC issued Memorandum Circular number 01-2020, Authority and Guidelines on the Conduct of Online or Virtual Proceedings for CIAC cases, and also CIAC Memorandum Circular number 02-2020, Protocols on the Use of Electronic Signatures in CIAC Case Proceedings. Now, this is the next slides will show or how we visualize this, and this is available to all who are interested in CIAC proceedings, and also the accredited arbitrators and mediators. So of course we can see here that under the memorandum circular, there is authority given to mediators and also to arbitrators to conduct online or virtual proceedings. And these are some of the rules, or this would be the rules regarding that. No, now we cannot really discuss all of this because of time constraints. Now, and we can see here that SIAC office premises could still be used, no? But the use now is restricted because it is now subject to the rules issued by the government. Anyway, we expect this to change as the country loosens up because of well, let's say there are now less infections in the country, and hopefully by next year we expect to conduct training for arbitrators, and some of the segments will be face to face and no longer remote. So as we can see here, again, the number of participants may be decreased, but in person in a large venue, so the arbitrators can, if so desired by the parties, conduct on in person outside the CIAC premises. if that is necessary. Now, note that there will be no additional costs and expenses that may be incurred for the account of the parties who shall share in advance equally. But this one is more important. The deadlines for the holding of hearings and the issuances of the final award under the CIAC rules shall remain, because CIAC has rules for the issuance of the final award, and arbitrators who fail to observe these timelines, unless if there would be some valid reasons, may be sanctioned, they may be suspended, they may be fined, right? And we have some, again, guidelines when hearings are not necessary. So certain provisions of the CIAC rules are cited in this slide. And you see, again, we have the guidelines of online or virtual proceedings for CIAC cases. So these are guidelines for the hosting or organizing of telephone, video, and other electronic case proceedings. Now, as we can see here, the parties, or there would be there would be some consultation with the parties, and there are some of the available telephone, video, or other electronic platforms that may be used. Now, there would always be a backup, no? And the tribunal should make sure that there is an alternative means to conduct private caucuses. Again, the host shall notify all participants with the dial-in number or link, meeting ID, and passwords. Now, a week before the proceedings, there would be a trial run. And insofar as these trial runs are concerned, before the hearings, actually, arbitral tribunals in CIAC would already be using this as their, shall we say, pre-trial conference, so that more or less there could be speed in the hearing proper. And of course, we have this electronic conferences should be of sufficient quality. Okay, so again, there are guidelines for documentary evidence, and so it's now up to the parties to provide a hard copy or hard bundle of the documentary evidence. We can see here they should be pre-marked, clearly identified and paginated, annotations, notes, and markups free, and corresponding with the hard copies submitted by the parties. So we also have provisions for security and confidentiality, right? So only authorized participants are allowed to join the conference, and the host control who may screen share if this function is available, and the host shall lock the meeting after all authorized persons have served. So the participants are not supposed to share the dial-in numbers or links. Again, no unauthorized person shall record the proceedings. Only the host or the CIAC staff in charge may record the proceedings, and in accordance with another section of the CIAC rules. For parties with multiple participants, there should be all the participants should be visible to the camera. All participants are required to show the 360 degrees view of the room to ensure that no unauthorized person is present, and that participants must also use trusted firewalls and browser extensions to block tracking. So that ends the, but please take note that these are guidelines. And so the arbitral tribunal can be very flexible. Like, for example, there are instances when there are technical difficulties and all that, especially here in the Philippines. Now, in some cases, not everyone, not all witnesses may have the necessary technological facilities in their homes and so on and so forth, especially during those cases when everyone here in the Philippines were practically under house arrest. This infographics is available. You can contact with or you can go to the website of CIAC or the email address of the CIAC, because this infographics is distributed not only to the arbitrators and mediators of CIAC, but also to other parties who are interested. And as we can see, the infographics makes everything very, very simple. And perhaps that's one of the reasons why CIAC remains to be very competitive insofar as getting cases are concerned. So thank you very much. So that ends my presentation. And I will be staying here perhaps until the end of the program, so that I will be available for questions if necessary. Thank you very much. May I give up the microphone now to the next speaker.
Thank you very much, Attorney Mario Valderrama. Before we continue with the program, let us indulge you with a winning performance from the UST Saringawi Dance Troupe featuring the folk dance Tinikling. Tinikling is a rural folk dance from the Visayan Islands that mimics how the tickling birds dodge bamboo traps set up by rice farmers. Performing Tinikling for the folk dance category, the UST Saringawi bagged silver in the 2019 NCCA Sayaw Pinoy Dance Competition. Ladies and gentlemen, we bring you to the UST Saringawi Dance Troupe. the winning performance UST Salingawi Dance Troupe. Ladies and gentlemen, we now proceed to the reaction and panel discussion. To moderate this session, we have Attorney Maria Luisa Dominic T. Mauricio, Associate Solicitor 3 at the Office of the Solicitor General of the Philippines and an OADR accredited arbitrator. Ladies and gentlemen, I now turn you over to our moderator, Attorney Maria Luisa Dominic D. Mauricio.
Good morning. So good morning to all our colleagues and friends watching in the Facebook Live of OADR and in YouTube. I am Luisa and I will be your moderator for today's panel. First off, we would like to thank, of course, the Office for Alternative Dispute Resolution and ED Irene Alogok and the rest of OADR for allowing us to be part of your very, very successful national conference. And now let me go ahead and introduce to you our first reactor for today. Attorney Ricardo Onquico is the Litigation Department Head and regular ExCom member of CSIP Salazar, Hernandez, and Gatmaytan. He is a fellow of the Chartered Institute of Arbitrators, the outgoing president of the Philippine Institute of Construction Arbitrators and Mediators, the president emeritus of the Philippine Institute of Arbitrators, and a trustee of the Philippine Dispute Resolution Center. He is an accredited arbitrator of the Singapore International Arbitration Center, the Hong Kong International Arbitration Center, the Asian International Arbitration Center, the Korean Commercial Arbitration Board, the Philippine Dispute Resolution Center, and the Philippine International Center for Conflict Resolution, among others. Ladies and gentlemen, our first reactor, Attorney Ricky Onquico.
Hi, good morning, Louisa. Thank you for that great introduction. I'm very happy to be here. I'd like to thank the organizers, the OADR, for the invitation.
So, Attorney Ricky, maybe we can start with your reaction first, and then we can go ahead with Attorney Jeff and Attorney Luigi afterwards. So, yes.
Okay.
Thank you.
Yes, I was tasked to react basically to the speeches of Attorney Arevalo of IPO Phil and Attorney Valderrama of the CIAC. I'm very happy to note about the progress of the IPO Phil with regard to online mediation, and I'm impressed that he mentioned, I think there were about more than 1,700 cases which have gone through online mediation, and they've had a reasonable success rate of about 40%. If I'm not mistaken. So this is compared actually our experience in arbitration for IPO-Phil cases. Compared to 1,700, I understand for arbitration there has been just a handful. And that's probably one of the things that my first reaction would be was that because I think after mediation, parties tend to go not to arbitration by a third-party arbitrator, but to be adjudicated by the IPO-Phil officers. And this has slowed down basically arbitration progress in intellectual property cases. But as you mentioned, because of the COVID-19, IPO-Phil made sure that it was able to continue to deliver its mediation services to the public through various memorandum circulars, authorizing at first the online mediation, and in the end mandating online mediation. I'd like to point out that in other jurisdictions, basically ODR is used also substantially for mediation. Why? Because ODR in other jurisdictions, for example, cost less, unlike commercial arbitration that we know here in the Philippines. And basically there's a need for the Philippines to catch up with the use of ODR platform for arbitration for intellectual property cases too. He mentions the need for investment by the Philippine government to come up with the ODR and the resolution process for intellectual property cases. And that's true. In the past, we had studied why the Philippines has lagged in connection with the enforcement of contracts In the past, for example, Korea was number 2 worldwide for the enforcement of contracts, while the Philippines was at the time about 112. And in the study, we find that main reason for the high status of Korea was the investment in hardware and software to conduct civil litigation through online, through the use of online and other technology. And the Philippines basically lacked the funding to have these, at the time, lacked the funding to have these technology and hardware to conduct online civil litigation. But in recent years, because of the pandemic, as everybody would have known, basically courts have invested money to be able to conduct virtual hearings also. So although that is a start, there's still a problem of having this in all the courts in the Philippines. Even in some courts in Metro Manila, in one recent experience, the judge said that he could not undertake online hearings, for example, because of the lack of sufficient connectivity and lack of sufficient computers to enable an efficient and effective hearing of the evidence of the parties. So I agree with that statement by the IPO Phil, the need for investment. I turn now to the speech of Attorney Valderrama of the CIAC, and I commend the CIAC really for their basically reaction to the pandemic, to the COVID-19. Like IPO Phil, CIAC was in the forefront really to continue with its service of providing arbitration proceedings for construction disputes. And in fact, Attorney Valderrama mentioned the memorandum circular that was approved by the CIAC. And for everybody's information, that was approved as early as June of 2020. And basically, this was much ahead of even the guidelines for online or virtual hearings adopted subsequently by the Philippine Dispute Resolution Center, which is the primary commercial arbitration center we have in the Philippines, as well as the Philippine International Center for Conflict Resolution, the new arbitration institution organized by the IBP. But at this time, both of these commercial arbitration institutions have also adopted the guidelines for conducting virtual hearings. And this has resulted in commercial arbitrations, and in case of CIAC, construction arbitrations to proceed as before. Although I think our experience in 2021, there were less cases that we have. We are still optimistic that the parties will soon continue to submit their disputes, construction disputes, to the CIAC. I urge everybody to take a look at these guidelines and memorandum circulars so you can see how these arbitration institutions basically use online dispute resolution through their virtual hearings or conduct of virtual hearings and arbitration meetings entirely online. We foresee actually in the arbitration community that even after the pandemic, virtual hearings will be here to stay, at the least, as the experience also in the regional institutions, as mentioned by Kevin Nash of the SIAC. We foresee that at the least there will be hybrid arbitrations where certain stages of the proceedings are held online or virtually, and so the more important stages like hearings of witnesses in disputes which are very complex to be done face to face. If you take a look at these guidelines, you will see the CIAC guidelines is quite short, and basically I think it projects really the quality of the Filipinos to be resilient. The CIAC arbitrators are very well experienced. They've been conducting arbitration since the late 1980s. And basically, the CIAC arbitrators have been able to adapt to the need for technology to continue with the arbitration process. Again, the issues that were sought to be addressed by these guidelines include the confidentiality of the arbitration process, and therefore there are certain procedures that need to be followed to ensure that the arbitration proceedings are only attended by those authorized to attend: the tribunal, the parties, representatives, their counsels, and their witnesses. No? So there are guidelines for arbitrators or hosts of these meetings to the use of security measures, like use of passwords, and also locking down the meeting after everybody has arrived to avoid or prevent third parties from coming in. So let me just say that what we lack in the Philippines right now probably would be the online dispute resolution process found in other jurisdictions, including the EU, for example, where all stages of the proceedings are held online, from the filing of the case, the payment of the fees needed, the appointment of the tribunal or the mediator. No, what we have is only the conduct of arbitration hearings or mediation meetings virtually. No, and then also the issuance of the award, as well as the delivery of these awards. So there's still a need for the Philippines to study this and to invest in these ODR platforms to enable the parties, the public, to be able to use the mediation and arbitration entirely online. Finally, I'd just like to note the CIAC is presently looking at this. In fact, they've organized a committee with the auspices of the CIAP to study the provision of entirely online dispute resolution process. It may take a long while, and also a need for probably allocation of some budget for this purpose. But we're confident that in 1 or 2 years that you'll see CIAC arbitration in particular to be conducted entirely online. Thank you, Louisa.
Attorney Mauricia, you are on mute.
Hello. Thank you so much, OADR. I was talking already there, but as I was saying, well, my mic was on mute. Thank you, Attorney Ricky, for giving us a very comprehensive background of how Philippines has actually stepped up during the pandemic to keep up with the online dispute resolution procedures that are needed in this particular environment. Now, let me go next to our next reactor before we do a complete discussion about how the Philippines is actually being at par in online dispute resolution. So our next reactor is Attorney Jeff Constantino. Attorney Jeff Constantino is a partner at Cadiz Tabayoyong and Partners. He is also the IBP Deputy General Counsel at the moment, and he is also presently the Vice President for Fellowships and Member Relations of the Philippine Institute of Arbitrators. He is an accredited arbitrator and the Corporate Secretary of PICCR and a trained arbitrator of PDRCI. And he is also a part of the list of trained tribunal secretaries of the HKIAC. Ladies and gentlemen, please welcome our second reactor, Attorney Jeff Constantino.
Good morning, Louisa. Thank you very much for the generous introduction. And I also would like to thank the OADR for the opportunity to be able to be part of this second ADR conference. So I'm going to react on the the presentations of Mr. Nash and Mr. Claxton a while ago. Well, I think it's best to begin with a review of a brief review of the existing literature on ODR. If we get to look at existing articles on ODR, it appears that ODR has already been with us in the in the late 90s with the advent of the commercial use of the internet. It's where it also came. The ODR was instituted as part of the dispute resolution process for online purchases and for domain name disputes, for those who have created websites in the internet. So if we can see, these two primary disputes are, some authors consider these disputes as disputes that are best resolved through online means, and therefore ODR as early as late 90s to early 2000s, there's already been mechanisms for online dispute resolution for these two disputes, because again, our authors are looking at these are the disputes that are best resolved online because your invoices are online, and of course your creation of your website is best evidenced online. Now, going to the present, it seems like ODR is now forced by the circumstances to also encapsulate or to also take over or become a significant part of the present or alternative dispute resolution environment. So before, disputes that are best resolved by online, it has transformed into, I think, because of the current pandemic, we have to resolve our disputes online. It may be best for us to resolve our disputes online. So as we go now to the presentation of Mr. Nash, I find it interesting that SIAC has already developed its own frameworks in relation, and I find that these are very much consistent with the recently released framework guidelines of the SIARB on the use of technology in arbitration. Briefly, the SIARB guidelines provide that while the arbitrators have power to conduct the arbitration in a manner that they consider appropriate, it is still important for the arbitrators to consider their duty to treat the parties with equality, give them full opportunity of presenting their case, and the duty to carry out the tribunal's mandate and not delegate it to others. Well, which essentially is encapsulated in the bigger blanket of due process requirements. So it's interesting that the Singapore jurisprudence has already provided an interpretation of the duty of full opportunity to present your case as a reasonable opportunity to present, which I think would help to try to address all difficulties of online dispute resolution. Next, I proceed with the presentation of Mr. James Claxton. I find it interesting that based on studies, it appears that trust building in-person mediation did not change with the advent of online mediation. So it's just a matter of how long will you be able to build trust. And I think looking at ODR in the face of in the aspect of mediation is different, because in mediation is more of immersive to the parties as compared to arbitration, where the arbitrators have to really be detached from the parties. Okay, so I think those are my 2 points. Thank you very much, Louis.
Thank you so much, Attorney Jeff. So I kind of had to look if I'm on mute or not. But hello, thank you so much for that, Attorney Jeff. And it was a very comprehensive reaction as well to the best practices that our two previous speakers have put forward, both for arbitration and also for mediation. Now let us go on to our final reactor before we go on to our panel discussion, and that is Attorney Luis Gregorio Jesus de la Paz. Attorney Luis is an officer and an active member of the Philippine Institute of Arbitrators, as well as a member of the Philippine Dispute Resolution Center. As a recognized arbitrator, he is proud to have as one of his accomplishments the fact that he has settled several of the cases that he has handled without having to go into prolonged litigation. In his role as a litigation and dispute resolution lawyer, Attorney De La Paz has handled several challenging scenarios, such as when he was able to secure a restraining order and eventually a prohibition against an influential government agency. He has also worked on several cases against government regulators to protect corporate interests. Attorney De La Paz currently sits as the legal counsel for the Worldwide Fund for Nature Philippines, where he has assisted in a pro bono capacity on several environmental and sustainability projects. Ladies and gentlemen, our third reactor for today, Attorney Luis De La Paz.
Hi, Luisa. Thank you so much for your kind words. Attorney Ricky and Attorney Jeff before me have already laid excellent groundwork, and they've shown the mechanics of ODR and how ODR can really help. My part of the reaction is Carolyn Nicholas, where she discussed the progress that the UNCITRAL had taken in developing ODR. And I'd like to point out that never has it been more apparent, except, particularly during this pandemic, the importance of ADR. When borders were physically closed, trade and business still had to go on. And instead of your traditional brick and mortar stores, people were resorting to other means, online means. By resorting to these online means such as Facebook, Instagram, eBay, they also remove the borders. And so a seller before who might have had a small stall in Green Hills is now finding that they're selling to someone in Hong Kong or in Singapore or the United States. And so this brings about a very interesting challenge. When you are out, and as pointed out by Carolyn Nicholas, when you are part of a system that does not have a grievance machinery in place, where does that place you? How is your trade protected? How are these commercial transactions resolved should there be any disputes? And so the UNCITRAL, as early as 2010, had identified this and had started working on this. And what we are seeing now with these UNCITRAL rules on ADR is a culmination of a decade's worth of work in this field. And it's quite amazing, really, because even 10 years ago, they already anticipated that this would be an issue. And so, where this is relevant to us, I feel, is that as more and more people take to the internet to conduct their business, to do negotiate, to do trade, to do buying and selling, it will become more and more important. And providing these sellers with the facilities, with the capacity to be able to enter into these transactions without fear of having no recourse. What you want to instill in online trade and online sales is really the trust factor. I myself, from personal experience, um, there have been some trades here and there, and you wonder what is there to um, what is there to protect me should the other party not deliver on their promise. And so there are the ODR rules of the UNCITRAL do provide us with that avenue and do provide us with that degree of confidence that is needed to conclude the transaction and to promote and encourage trading with and commercial transactions. And so I feel that it's very exciting, the developments. Certainly this is not the last, nor will this be the end of it all. I see that there's still a lot of growth to be made here, and I look forward to the time when small and medium enterprises in the Philippines take advantage of this and expand our sales, our commercial transactions, not just within the country, not just within the region, but the entire world as well. Thank you, Lou.
All right. Thank you so much, Attorney Luis. And as Attorney Luis correctly pointed out, and as we have been hinting on a while ago, the Philippines is almost at par to all developing and developed countries right now in terms of putting in place a procedure for online dispute resolution. And many thanks to the very, very aggressive stance of the OADR in trying to put up this very infrastructure for the Philippines. And that ends the individual reactions of our reactors. Now what we want to do is bring everyone to this discussion. So we will be putting on the screens Attorney Jeff, Attorney Luis, and Attorney Ricky for some questions. First from me, and then of course from our viewers, which the OADR Secretariat would be helping us. So please, if our viewers from Facebook and YouTube would have any comments, suggestions, questions to our panels, please type them down. The chat boxes over there, and then the OADR Secretariat would be migrating it to us so that our panel can address those questions. Now, I do want to start the questioning with a very obvious question. And it's related to the fact that throughout the last few years, not just 2020, but about a decade ago, there has already been a steady move towards digitization and a transfer of a good deal of work by humans to technology. And our speakers have hinted on this in their speeches. But really, the pandemic has sort of sped up the process and made technology a necessity. Technology became the only way to communicate, let alone solve a dispute. And this leads me to my first question. In the Philippine setting, and maybe we can start with Attorney Ricky, how much or how little do you think has the pandemic really pushed even the most traditional lawyer to embrace the utilization of online dispute resolution proceedings?
Thanks for that, Louis. Well, I think the pandemic has pushed everyone to embrace technology. So you have first the typical litigators, for example. The Supreme Court has mandated that hearings be held online, and therefore, and you have judges, of course, that would follow that and schedule hearings online. And you cannot have the hearings postponed for so long unless you embrace the use of technology. So we find, but soon after, several months after the start of the pandemic, that the courts have up and allowed for not only follow-ups online, but also submissions of pleadings online, as well as hearings online. And as mentioned, the arbitration institutions in the Philippines, led by the CIAC, the Construction Industry Arbitration Commission, have adopted their guidelines, their circulars with regard to online proceedings, forcing parties really to embrace the use of virtual hearings so that the arbitration will not be postponed, will not be further delayed, and awards may be issued. I think Kevin Nash of the SIAC mentioned that after just a couple of weeks of a pause, the parties internationally readily adopted virtual proceedings. And I think SIAC, the HKIAC have experienced record numbers of cases submitted and resolved during these 2 years of 2020 and 2021. Probably because of the availability of hardware and software in Hong Kong and Singapore. I think Philippines can follow if we find that hardware and software. But in the end, I think people have seen how easy it is, how less costly it is, how convenient it is to adopt these virtual hearings, online meetings, and I truly believe it's here to stay even after the pandemic.
All right, thank you so much, Attorney Ricky. And you've raised very great points out there, but I just want to pick and choose so that I can go to our next question. And maybe I can ask Attorney Jeffrey here, based on Attorney Ricky's exposition on how much even our Supreme Court is very supportive towards online dispute resolution proceedings. Do you think there is still some backlash of some sort? Are there still this particular group of lawyers or advocates that are sort of averse to online dispute resolution? And if yes, why?
Uh, okay. Uh, to answer that, um, let's first take a look at the context of the beginnings of ODR, as I tried to mention a while ago. Before, it was a take it or leave it scenario. When you purchase online, you can purchase online. You can try to but when you purchase online, you have to subject yourself to our dispute resolution, which is we will just refer your complaint by email to the seller, and hopefully the seller will respond back, and hopefully it gets resolved. For domain names, well, it's again a take it or leave it scenario. You can choose to create a website, and then by creating a website under our domain, you subject yourself to our dispute resolution mechanism, which is primarily online. Even as early as the late 90s, we're talking about that. Now, in this context, we are faced with a scenario where even if you don't want to, even if you don't want to, even if you're the most stubborn of lawyers when it comes to technology, the main stimulus is the wishes of your client. Right now, it's no longer a matter of take it or leave it. It's a matter of I need it. Our business needs it. So it's either you have to move forward, or you consider yourself, or you mark yourself as a relic of the previous generation, which will somehow be detrimental as well to your practice. So it's no longer really a matter of just, okay, let the younger lawyers take care of technology. I'm okay with I think I can very much try to wait and weather the storm. But I think the environment, especially the commercial environment right now, is even businesses can't wait. So even if the businesses can't wait, what, well, how can we sure that you are in a position to consider yourself that you have the time to wait? So I think that's the stimulus for everybody right now, primarily because with the pandemic, I think it's only reasonable that we get to see, or that we get to be an instrument of helping everyone get back on track. And it's primarily letting businesses get back on track. And in a commercial transaction, it's rarely that you enter into a commercial transaction without any reasonable possibility of a dispute. So you open yourself to a transaction, you open yourself to a dispute. I think that's automatic. So the primary stimulus is everybody has to get back on track. You have to do your part, regardless of you are in a technological generation or not. So that's my take on it. Thank you.
All right, thank you so much, Attorney Jeff. And you pointed out a very good point over there that right now it's really a take it or leave it sort of thing. That if you really want to do business, you would have to go through these online mechanisms for the simple reason that the particular situation, the COVID pandemic situation, has forced us to do this. And I would bridge this to my next question to Attorney Luis, to ask you, maybe since this is already a necessity, how much of our population, the Philippine population, is actually ready or has access to this particular technology, given the fact that it's already a necessity for dispute resolution?
Louis, that's a very interesting question. And without going into the accomplishments of the DICT and the various government agencies who have indeed been doing their best to try to connect all 7,107 islands, there is much progress to be made, certainly. It doesn't help that we are 7,107 islands. It doesn't help that there are physical there are geographic and territorial challenges to accomplishing this. However, a there is a ray of light here. Um, if there are X million, I think the number is around 40 million TikTok users in the Philippines. Not to mention the millions that are on Facebook and the 223 people who are now viewing this program. That is a good sign. That is a good sign because and to connect this to what Jeff had said earlier, I think it's a mindset thing. One of the greatest obstacles to accepting and adapting this technology is your mindset to it. I remember the first time I had to convert my dad from his old Nokia to the new touch phones, and that was a 6 month. That was a 6 month tutorial that would never end. And every Sunday when we'd have lunch, I'd have to tell him, "Dad, these functions have changed, but you're doing something better." But he said, "What was wrong with what we did before?" There's nothing wrong with what we did before, yet circumstances change. And as the pandemic came, it has shown us that certain things might no longer be necessary. Certain things can be improved. And along those lines, on the mindset issue, I feel that the capability is there. Um, as Attorney Ricky touched upon, the certain rules such as control, the technology that you need, if the capacity to share your screen, to share your evidence, and how clear this can be, because primarily it is akin to mediation where it matters how you say and what you present. And that will make a huge difference in settling the dispute. And I feel that as that improves, then people ha- we are probably number three in the world in per capita cell phone to person usage, next to the United States and to Indonesia. And I don't see why these things can't be done through via mobile phones. And most of the trading is done there. There's payments through GCash or PayMaya that are already made. Transactions are made virtually on the phone, and so we're there commercially. We're there. We're already doing our trading. We're doing our commercial transactions through mobile platforms. So ADR is a natural step. It's a natural necessity, and it's just about our mindset now. Is this some? Can we get over our aversion to it? Because we have to learn how to accept and to trust. I guess I think that's the key word there. We need to trust the technology.
All
Right. So
right.
Louis, if I can add,
yes,
I was just going to say, I think you just have to take a look. Prior to the pandemic, I remember going to restaurants and seeing toddlers, 2 years old, 3 years old, with their families, and they're in front of cell phones or their iPads already. They know how to use them. So I'm thinking really we have to take advantage. Filipino youth has greatly adopted to this technology, and us in the dispute resolution committee can take advantage by providing them with platforms, no, for dispute resolution entirely through the use of these devices, the internet. Thank you.
All right. So thank you so much, Attorney Luis and Attorney Ricky. You guys pointed out a very good point, which is we actually have the access right now to the hardware, to the technology in order to bridge ourselves to ADR. But my next question would want to go to the quality of that access. And maybe I can stick with you, Attorney Ricky, to ask you, it's one thing to have a cell phone. It's another thing to have the requisite bandwidth to actually be speaking, to actually be advocating your particular position to an arbitrator or even to a mediator, and even to your other party, that is. So I just want to ask you, how much do you think is the lack of bandwidth quality here in the Philippines really, does it really affect a party's opportunity to fully present their case in, for example, an arbitration or even in any dispute resolution proceeding?
Yeah, in my experience, actually, in this past pandemic, no, I've conducted hearings and meetings with parties using online or virtually through video conference, just using the commercial applications that we have, no, that's readily available. And I can't remember, or maybe just a handful, one or two hearings or meetings that may have been postponed just because the parties involved did not have enough connectivity, enough bandwidth to undertake the process effectively and efficiently. So what happens, for example, in arbitration, also in CIAC arbitration, Attorney Valderrama talked about trial runs, tech runs prior to the hearings. And that is very important because that is the time that everybody will know if they have sufficient capacity to conduct the hearings effectively. So not only the counsels, but the parties' representatives, as well as the witnesses and the tribunal for arbitration. In these trial runs, they're able to find out that if they will be able to go through the process effectively. Actually, the postponements that have happened was because of COVID. Some counsel or witness got infected with COVID, and therefore there was a need for postponements. But of course, the other question is, okay, they can go through the arbitration hearing or the process. The question is, can they do so effectively? As an arbitrator, I find, well, of course, we have hearings where the hearings is interrupted because of some connectivity problems with one of the witnesses being questioned or one of the counsels who is asking the question. So, and therefore we have to adapt. I find, as I mentioned, Filipinos are resilient. We don't let these little things bother us so much. We're very patient with the lack of, for these difficulties, because we understand that we being just a developing country don't have not all of us have sufficient internet connectivity or even the devices, and because of this, I think we've been able to go through our hearings here, all these evidence presented, and be able to issue our awards based on the evidence presented by the parties. And I remember in all these cases that I've heard through virtual hearings, we'll ask all the parties, if at the end of the hearings, if they were happy and can confirm that they were able to sufficiently present to the tribunal all the evidence that they wanted to present, and all of them said yes. So notwithstanding all these problems we have being a third world country, we cannot compare probably with more developed countries in the region with regard to connectivity and other software and hardware that they use. But I think we're able to push through and serve, well, in our case, the arbitration community, serve our disputants effectively.
All right. Thank you so much, Attorney Ricky, for that very good experience that you shared. And it really connects with something that the 2021 Queen Mary survey had actually pointed out, that the fears about virtual hearings was really in the start of the pandemic. But then as we went through all the hearings, we tried to understand each other, understood the connectivity issues and all the other barriers that we would have to go through. It would seem like the virtual hearing process and even the entire dispute resolution process has been going smoothly. And just to connect with that, we see one question from our Facebook live, and I think Attorney Ricky has answered this a bit already a while ago, but I just want to ask Attorney Jeff to start with, what are other disadvantages other than connectivity of online remote hearings? So that's the question.
Okay. If it's a local scenario, I think the disadvantages are very minuscule. I think it's really more on the connectivity issue, but the connectivity issue, and again, perhaps one thing that can also come to mind is the with respect to the authenticity of documents, the fear that somebody might be using spurious documents, and you will not have the opportunity to scrutinize it really well in an online setting. But I am inspired by one of the, in a previous talk last Monday, one of our speakers was Attorney Teddy Calao. He gave an interesting point that I think the solution to that, especially on documents, is for the parties to agree that when it comes to an arbitration or remote arbitration hearing, the presumption should be that the document is genuine. It should be going into the arbitral proceedings, all documents that will be presented will be assumed or will be presumed as genuine and authentic. And it is the burden of the party would try to question, to raise that question or to challenge that particular document. So I think it's more of the other way, putting the doubt the other way around. So it's more of a presumption towards genuineness of a document. Okay. So
All right.
for me, that's all.
Thank you so much, Attorney Jeff, for that particular disadvantage, which is something to do with evidence. And maybe I can quickly ask Attorney Luigi also. Would you have another disadvantage in mind of online remote hearings, and maybe a quick solution to it as well, as Attorney Jeff had actually given?
Well, one of the challenges in online dispute resolutions or in online hearings, really, and in my experience, it has been the comparison, the verification, authenticity of certain documents. While in ODR, we are thinking of electronic and online transactions, there will be perhaps some paper trail there, which someone will want to see, and certain lawyers like to feel it. It has to be something tangible, and it's hard for them to overcome uh, the fact that they can only view it. But there are ways around this. There are watermarks that can be placed. There are seals, and with blockchain technology, there are ways to authenticate these electronic documents to ensure that these are faithful reproductions of the same. And so there is no hurdle currently that is being faced that cannot be overcome, I feel. And I think, and I look forward to the time that we no longer have to take up that space to physically be there and to expose other people, that we can just do things like this virtually. I think it's more efficient, especially in the Philippines, where travel time, you lose your entire morning for just one hearing, really. I think Ricky remembers the time where you start.
Yeah.
And so I'm not looking forward to that. Certainly no.
Louis, if I may share one
Yes.
difficulty as a counsel, arbitration
Yes.
counsel. No? In face-to-face, basically, you have a team handling the arbitration or the litigation hearing. And in face-to-face, you're able to share views during the actual hearing itself. Um, Also, with regard to the witnesses, for example, the witnesses can see his counsel right there in front, and therefore can gain some confidence, or sometimes look for some hints that counsel may give in answering the questions. But in virtual hearings, that's all gone, especially if, for example, the witnesses and each of the counsels are attending it in their own same office spaces or homes, so they're just attending it virtually. So as a counsel, for example, one difficulty is really interacting with your team. Nobody can help you, and therefore, if you're the lead counsel, you're the one asking question, a lot of times you have to do everything yourself. And there's a need for prior consultation, for example, as to who will share documents. Probably in that sense, you assign a member of team to share some documents so that the lead counsel can just concentrate on asking the questions. So, but in any case, the communication between the team is very difficult. Sometimes you have a different device, Viber group, or WhatsApp, and they're communicating at the side, not in front of the tribunal or the court. As far as the witness is concerned, that's the other problem. You have to make sure that the witness will be able to effectively give his testimony is confident. To give his testimony online without any person near him, or without seeing his counsel beside him. And I think that requires, for example, for counsels to make sure have more than preparations with their witnesses to ensure that the witness is capable of giving their testimony effectively. And if the witness, for example, turns out to be somebody who's really afraid, stressed about all the hearings, and needs somebody there to hold their hand, then maybe you could make arrangements that one of the members of the team go to the place where the witness is, to help in the testimony, like giving them documents that the witness needs to see, or at least the presence of the counsel will give that witness confidence.
Attorney Ricky?
Thank you. That's it.
Okay, thank you so much, Attorney Ricky. And I think that's a very good point to point out, actually, that it's not really for anything else, but really for the confidence of not just your witness, but you as a counsel, that you have your team with you advocating for your cause. And I see the time, and it's been really great talking to everyone. I hope everyone enjoyed our little discussions. We can go on and on about virtual hearings and online dispute resolution, as you may have probably surmised. But we have to end day two of our national conference. And before we do end, I just want to do a one quick question, sort of a closing for our panel. And my question relates to one particular thing that the 2021 Queen Mary survey has actually pointed out. In that survey, it said that 45% of the respondents prefer their substantive hearings to be done in person once the pandemic ends. And I want to ask the panel for your quick answers. Whether is this true for you when the pandemic ends? If it really ends, would you prefer to do some of your hearings physically, or would you want to retain this virtual setup? And maybe we can start with Attorney Ricky, and then Attorney Jeff, and then Attorney Luis.
Yeah, I think it's a little higher for me, like 60% or something, because I've seen the advantages of virtual hearings. Also for client, the less cost, less time in traffic, in Manila traffic, as Luigi has pointed out. And I find, for example, the experience is good. It has been effective. We were able to issue good awards for arbitrations that were with virtual hearings done. And so I think it's a little more than that. 60-40 for me, Louis.
All right. Thank you so much, Attorney Ricky. Attorney Jeff? You're on mute.
Okay, sorry for that. For me, I think the 40%, the initial the 40% of people would want to go to for opting for a personal hearing or in-person hearing. Yeah, I think I share Attorney Ricky's view that I think it must be higher. Uh, but for me, it's more of because people are really raring to interact more in person. So I think it would be more of a wait and see. The I think the survey was done in anticipation of people wanting to really enjoy the outdoors again, and trying to renew in-person relationships and then interactions. So I think that's probably a factor to that. But as the years or as our adjustments to the pandemic develop, I think it would straddle along a hybrid, more of a hybrid scenario. And one last point is that I think the we also have to take into consideration that the current surge in the online or in the remote hearings was forced upon us. So was really forced upon us by the circumstances. So it's really us trying to accept, or it depends on our appreciation and acceptance of the situation, where the parties will try to somehow will determine the parties' continuing support for online hearings or in-person hearings. Thank you.
All right. So Attorney Ricky prefers virtual hearings. Attorney Jeff is somewhere in the middle. So Attorney Luis, where will you be?
Okay, so let's break that tie. And I know where it should be. I see from Jeff's point that is the reality. For us folk that they're on the ground, so to speak, and attend the hearings physically and see. There is a sentiment. There is a different feel. After all, I started out as a litigator, and I like the thrill. I like the presence of being in the court. I like when the judge calls a case. I like being in front of the panel, and it makes me feel like a real litigator. And this new online thing is, well, it's a different feel, right? But at the same time, I do understand the need to adapt and the need to move forward. And if we have a way that is more efficient and that can dispense of cases, as Attorney Ricky pointed out, cheaper, faster, why don't we avail of this? Because our real role here is to make these mechanisms available to everyone and not just a select few. And so if we can change that mindset of ours and embrace the change that is happening, then I can see the Philippines overcome its challenges, that are being presented by it being a developing country. There's no reason why we can't move forward with this, and I hope that we take a step in the right direction, starting with this ADR seminar which you guys put together. Thank you, Louis.
All right. Thank you so much, Attorney Luis, for breaking the tie. So, and that really ends our time with you. We hope we were able to give you a little bit of insight about digitization of ODR here in the Philippines and also internationally. Again, I am Luisa, and I was your moderator. And we again thank the OADR for allowing us to be here with you today. So right now, we want to turn you over again back to the OADR Secretariat.
Thank you very much, Attorney Mauricio, and to our panelists and reactors for the insightful and interactive session. Exciting times ahead indeed for Philippine ADR. We have now reached the end of our program. To deliver the closing remarks, we call on OIZ Director of the Training, Accreditation, and Promotion Service of the OADR. Ladies and gentlemen, let us hear from Attorney Ali Lorraine V. Manrique.
Morning, good afternoon, and good evening to all our speakers and guests from all over the world. As we close the second day of this convention, we have seen how technology remarkably transformed the landscape of dispute resolution. This digital era holds a promise, one that transcends physical boundaries while enjoying a higher degree of transparency, participation, and change. Technology changes the traditional theory and practice of ADR in a cycle that characterizes these times of global accelerated transformation. The pandemic has significantly changed the delivery of public service with just over a year since its onset, especially the aspects concerning the justice system and court operations. Through the many challenges that the government agencies have faced, it is pleasing to see how both the public and the private sectors hurdled this enabled a great deal of positive innovation in improving the administration of justice through the use of ever-evolving technology. In the traditional justice systems, important touchpoints would mean critical meetings between actors within the justice system. The continuity of such critical touchpoints was at first hampered in the wake of COVID-19. However, it was also during the dreaded outbreak the justice system witnessed the significant role of technology for its accessibility and administration more than ever. With digital platforms, lawyers and judges alike are able to access information right at their fingertips, including legal documents, case bundles, case libraries, and up-to-date schedules of hearings, as well as communicate and collaborate in real time. Court hearings may now be held online, and everyone can remotely attend to sessions even with the use of their smartphones. Today, we have heard from our esteemed resource persons how online dispute resolution, or ODR, offer a new way of resolving claims and disputes, and how the ADR practices adapt to the accelerated digital shift. By using digital platforms outside traditional court systems, the ODR dispenses with costly and tedious litigations. Through ODR, disputing parties, together with an arbiter or a mediator or any neutral third party, can duly resolve their cases remotely, hurdling geographical boundaries using various applications and digital platforms. ODR's appeal lies not in engaging the expensive service of lawyers or spending ages in the courtroom. As long as the parties can get connected online, ODR affords the willing disputants the ease of access to justice. The convergence of the physical world with the virtual realm has brought with it a range of novel issues or complex transactions and relationships. It has also brought with it the inevitable need for appropriate dispute resolution processes, as well as applicable guidelines for the proper conduct thereof. Thus, it is incumbent upon us to address the challenges that come with the price of innovation. For instance, IT systems and case records necessitated security measures from cyber attacks. Also, new online processes were needed for addressing disputes. Tools and systems for the purpose were developed, evolving from online equivalents of traditional processes such as negotiation, mediation, and arbitration, to a more varied selection in which the unique qualities of online processes were no longer seen as constraints, but as advantages that could complement, if not enhance, these face-to-face dispute resolution mechanisms. It is our hope that you have learned from our guests, and you will be able to translate it into your own good practices in disputing conflicts through digital means. As the OADR continue to perform its mandate to promote the use of ADR in both the public and private sectors and assist in the delivery of speedy and impartial justice, the office will mainstream ADR as a primary way of resolving disputes. Consequently, the office will recommend the much-needed amendment, adoption, and/or improvement of ADR policies to incorporate recent developments in the field of alternative dispute resolution. The OADR has achieved great strides towards its vision of an enlightened society that rises above conflicts and empowers party autonomy. We assure you that our advocacy does not stop here. We will continue to explore, innovate, and improve promotional activities in this pursuit. I would like to end my closing remarks with a challenge to our partners and advocates. Together, let us make ADR accessible, borderless, and seamless to ensure fair and effective justice for all. Thank you, and stay safe, everyone.
Thank you very much, Attorney Manrique. To all of our participants, please follow our official Facebook page, Office for Alternative Dispute Resolution, or OADR, for more updates about the convention and all other ADR-related information. Join us again tomorrow at 9 o'clock in the morning for the third day and finale of the NADRC 2021, focusing on regulating the online dispute resolution and its integration into the legal system. This has been day 2 of the second National ADR Convention with the theme Justice in the Digital Era, Synergy of Traditional ADR and Technology. Thank you very much for joining us today. See you again tomorrow. Good day and keep safe.